Hello, everyone, and welcome to our webinar. Today is the kickoff for the NCAA's March Madness tournament, and our webinar today will address the hot issue of student athletes being compensated. I am Caroline Kane, and I'm excited to welcome you all here today. Just some housekeeping. Everyone logged in today's program will receive an email that will include a link to the recording for today's webinar and a feedback survey. For those of you who are seeking MCLE credit, please complete the feedback survey in order to be eligible. So with me today are my colleagues. We have Jason Patterson, Emily Tulloch, and Mike Warner. All of us are attorneys at Franczek PC in Chicago, Illinois. And a little bit about our firm, for those of you who might not know us, we focus our practice in the key areas of labor, employment, and education. Our clients include both private and public sector employers, as well as educational institutions, including those in higher ed. Our firm represents and advises colleges and universities throughout the country on both labor and employment issues, as well as student-related issues. So our discussion today is surrounding the issue of student-athlete compensation. All of you, I'm sure, have been following this issue in the past few years with all of the legal challenges to the NCAA's principle of amateurism. This topic is unique, and it is actually right at the intersection of what our firm does, touching on both student issues as well as labor and employment issues. Many of the legal challenges to the NCAA are surrounding the idea that student athletes are actually employees of the college or university that they play for. So with that, I'm going to kick it over to my colleagues to get us started on today's presentation. We do encourage all of you to chime in on these issues and share your thoughts and opinions. So please use the chat function throughout the presentation so that we can hear from everyone.
Thanks, Caroline, and hello to everyone out there. We have an informative yet entertaining, hopefully, presentation for you on a very topic that most people love, sports. So I want to kind of further set the stage just a little bit before we dive too deep. So, throughout the course of the presentation, the million-dollar question here is what is the appropriate allocation, so to speak, of resources generated from collegiate sports amongst the key players? So we're going to talk a little bit about just that very structure of college sports, how it works, some legal challenges to that structure, and then finally some proposed legislation addressing those key issues. At that point, we're going to do our best ESPN first take impression and passionately debate these issues as much as you probably do at home. We want you to, as Caroline mentioned, we want everyone to add their comments and positions on these issues that are up for debate. So again, please use the question and answer function to either provide your comments as we go, and especially at the end. We really want this to be as interactive as possible given the Zoom environment. So first, let's talk about, I mentioned key players, and let's get into who that is. So first, we have student athletes. Some students are chasing a dream of professional sports. Some are using sports as a means to an education, while others are just doing it for their love and passion for the competitive nature of sports. But in any case, they make the machine work. If we didn't have talented collegiate athletes, we wouldn't have much to talk about at all. Other key player, the actual college and universities. Of course, these are institutions of higher learning at their core, and they are dedicated to education, but they also can and do benefit from having a strong sports program. Then finally, we have the NCAA, which is a nonprofit that regulates collegiate sports. They receive a lot of revenue. Of course, it's March Madness right now in the basketball tournament. That is their primary source of revenue. And most of that revenue, or a big portion of it, with them being nonprofit, is just reallocated back to the member institutions. So a little bit about the structure. Like any operation, college sports is driven by business considerations. And according to the U.S. Department of Ed, just in 2018, nearly $14 billion was collected in revenue by college sports programs. So it comes from things like ticket sales, corporate sponsorships, merchandise sales, television contracts, so on and so forth. And just to give you some perspective, just in 2003, college sports programs put in just $4 billion compared to 14 billion in 2018. And that revenue growth increase is second only to the National Football League. So however, the revenue is not widely distributed, with only 3% of the schools bringing in 50% of that revenue. So you think about your big time college programs, they're kind of doing the heavy lifting there. So it adds an interesting wrinkle about what we're talking about when you start to think about who the real players in the game are, so to speak. So with that, I'm going to turn it over to Emily.
Yeah, so Jason mentioned that there's a ton of money in college sports, right? But where does that money actually go? And how much of it is going to benefit student athletes as opposed to the coaches or the universities that they play for? So currently, aid-like scholarships or stipends are really the only form of compensation that are available to student athletes. And the NCAA has reported that Division I and II schools provide approximately $2.9 billion in athletic scholarships each year to over 150,000 student athletes. So while scholarships really provide a tangible benefit of helping students pay for tuition, their housing, other school-related expenses, there's still a real market imbalance between the revenue that student athletes are generating and how that money is then used. So for an example, if we look at the budgets of the top 5 revenue-producing programs in the country, only 12% of that revenue is actually going to student scholarships. Coaches, on the other hand, are receiving 16% of the revenue for their salaries alone. And so, when we look at these top 5 programs, there's about 4,400 coaches that are receiving more revenue than the approximately $45,000 45,000 student athletes that are really generating that revenue.
So in looking back at how we got here, the NCAA was initially formed to create a uniform set of rules to regulate intercollegiate football. And historically, it's a self-regulated institution, but it looks a lot different today than it did back then. It operates as a private and voluntary association, and it has over 1,000 membership universities. So the NCAA has its own rules and regulations that govern college athletics, which now includes more than just football. And the colleges and universities are divided into 3 divisions, labeled 1, 2, and 3. And the designation of a school's division depends on what the school offers their athletes. So Division I schools provide the greatest number and highest quality of opportunities to their student athletes by sponsoring more teams and providing them with more financial aid compared to other schools. Football is kind of unique in Division I because it's further divided into 2 other divisions, the Football Bowl subdivision and the Football Championship subdivision. And FBS schools do offer more scholarships and are thought to be more competitive. Division I schools for both football and basketball are further organized into conferences, and these function as smaller leagues within the NCAA. Each conference is required to comply with the NCAA rules, but they do operate independently and generate their own revenue. They just have to be consistent with NCAA policy. So speaking of the NCAA rules, the NCAA does publish a manual each year that contains all the rules and regulations that membership schools are required to follow. It's focused on the NCAA's goal to differentiate itself from professional leagues and focuses on the educational aspect of college athletics. And this is often referred to as the principle of amateurism, which has been really the center of many of the legal challenges to the NCAA in recent years. So we pulled this quote directly from the 2021 manual, which states, "Student participation in intercollegiate athletics is an avocation, and student athletes should be protected from exploitation by professional and commercial enterprises." So the NCAA has repeatedly used this principle of amateurism in defending its structure as it exists and in prohibiting student athletes from receiving compensation beyond what is already provided to them in scholarships. So this includes any form of compensation for using a student athlete's name, image, and likeness. And as we discussed earlier in this presentation, the NCAA and its membership institutions, at least in Division I, make a significant profit off of amateur athletes. So their stated purpose in this manual is striking compared to what the NCAA is earning and how they're distributing their money, particularly when it comes to revenues that are generated through using student athletes' name, image, and likeness. So that's just something that we wanted to highlight in moving forward.
So what's wrong with keeping it just like it is? And that's kind of what we're going to be talking about today and some of the options for changing the current scheme. So one of the first issues that really comes to mind relates to fairness and equity. And essentially, coaches, athletic departments, and administrations of large institutions are really profiting off of student athletes that generate these huge amounts of revenue, while student athletes aren't being fairly compensated or compensated at all. There's also a pervasive race and equity issue really related to profiting off of, in particular, Black students, Black student athletes. And we see that the highest revenue generating programs are men's basketball and football that are predominantly populated by Black men. And so we have this equity issue that's being raised where institutions and individuals are really profiting from revenue generated by Black athletes in particular, which really calls into question whether their labor is being adequately or appropriately compensated, which is something that we've seen as a clear issue throughout history. We've also got these issues of corruption and sustainability, and I'll hand it over to Mike to talk a little bit more about those. Oh, you're on mute, Mike. The joys of Zoom.
Yeah. Thank you, Emily. One of the issues that often gets lost in the debate related to fairness and equity is the fact that, the vast majority of Division I college athletes are not going to earn their money through professional sports. It's one thing to say Trevor Lawrence, a quarterback from Clemson who's slated to go #1 in the draft, or Zion Williamson, the Duke player from my alma mater, by the way, who is, they'll have their chance to make money from sports when they go pro. But that's not the case for most athletes. And you can say they are getting a free college education, but the demands of being a Division I college athlete, indicate that the experience that a student athlete, Division I athlete, has as compared to a regular student is very different in terms of the demands on their time and what the school says their priorities should be. So, that's something that needs to be paid attention to. We could spend a whole webinar talking about issues of corruption. Anybody who follows college sports, knows about all the scandals that erupt every few years. Even the most careful schools are always in jeopardy of running afoul of the NCAA. As most of you who follow college basketball know, there was a significant FBI sting operation and investigation that led to several criminal indictments several years ago. And the structure of the current system just ensures that that's going to keep happening. As noted by Jason and Carolyn, there's so much money in the system, and with the students and athletes who are integral to that system being restricted by law and or NCAA regulation from being compensated, that money has to go somewhere. It ends up going to agents. It ends up going to less than savory individuals and purposes. And sometimes there's ways that those less savory individuals try and funnel money to players in violation of NCAA rules. Finally, there's the issue of sustainability. This system, while it generates a lot of revenue, isn't a profitable system. The majority of universities in the nation's top athletic conferences in Division I for basketball and in the FBS schools, they lose money on athletics, and they to the tune on the average of $16 million each. So this is not funds that are going towards education of students. It is not money that goes towards the university as a whole, and often any revenue that is generated because of the arms race in being competitive in recruiting, any money that is generated by or for the athletic program is funneled back into the program. So because the status quo has created all these issues, there has been an increasing number of legal challenges and legislative challenges to the status quo. The most significant area where students and people challenging the current NCAA regime have gained some traction is in the area of antitrust law. The first case, O'Bannon versus NCAA, this was a case brought about 8 years ago by Ed O'Bannon, former NCAA basketball player. It started with his observation that his likeness, number, appearance, even his shooting motion was being used in the NCAA Xbox or PlayStation video game, and he sued, challenging NCAA rules prohibiting athletes from profiting off the use of their name and likeness for commercial purposes by the NCAA. The case over the years that it was litigated expanded to a wholesale challenge on NCAA restrictions. Ultimately, case went to trial. The trial court did rule that the NCAA was subject to antitrust laws, and the court did rule that certain aspects of the NCAA rules were unlawful and issued an order that restricted enforcement of certain NCAA rules. One of the major rulings in the case was that the court ordered the NCAA to remove cap on what schools could spend on grant and aid available to student athletes. And remove that cap to any level below the cost of attendance at school. Prior to this litigation, schools were really restricted in what they could offer, either by the NCAA or by the conferences, above and beyond the cost of education itself. Under the O'Bannon ruling, schools were allowed to offer additional stipends and financial assistance for education-related expenses, room and board, and things directly related to education. The trial court also ruled initially that the NCAA and schools should set up a fund for student athletes that would allow reimbursement for name and likeness use of up to $5,000 per student. The case did go up on appeal, and the Ninth Circuit Court of Appeals, however, did reverse that part of the district court decision and held that the NCAA was not required to authorize the use of these funds to directly compensate students for the use of their athletes' name, image, and likeness. And ironically, the rationale used for this was the principle of amateurism. The court held that amateurism was a legitimate goal of the NCAA, and what distinguished the NCAA from professional sports teams and made it competitive in the market for sports and made it popular and economically viable was the idea that athletes were amateurs as opposed to professionals. So in other words, ironically, there's an argument to be made that this very decision allows continued exploitation of student athletes' names and likenesses, but in violation of the NCAA principles, but again, does not allow the students to be directly compensated for that use. Most recent case, and this was a decision that came down in January of this year, also deals with caps on aid that can go to students. This is the NCAA grant and aid cap antitrust litigation, again out of the Ninth Circuit. The Court of Appeals, following many years of district court, trial court litigation, ruled that, again, that NCAA rules limiting non-cash education-related benefits that student athletes could receive violated the Sherman Antitrust Act. However, it did, again, uphold the principle that the NCAA could restrict cash compensation that is unrelated to education to students. And that was not an antitrust violation, again, relying on amateurism, and that the NCAA had a legitimate business and competitive interest in upholding the principles of amateurism and restricting cash compensation that could go to students.
So some of the legal challenges to the NCAA have arisen under the Fair Labor Standards Act. This law generally requires employers to pay their employees a minimum wage and overtime for hours worked over 40. So you can see from the definitions on this slide that the FLSA defines employee very broadly as any individual employed by an employer. It also defines the word employ to mean to suffer or to permit to work. So looking at these definitions and knowing how broadly the FLSA applies to employees, it can be difficult to see how student athletes do not fall under this definition. However, courts have consistently held that student athletes are not employees under the FLSA. So although there have been a few challenges under the FLSA, the NCAA has ultimately succeeded for now in preserving amateurism by arguing that athletic activities are conducted primarily for the benefit of the participants or the student athletes as part of their education, and that it isn't the kind of work that is typically contemplated under the FLSA. So I just wanted to note that in some of the cases that have been brought, the court has relied on this U.S. Department of Labor Field Operations Handbook. And within the handbook, the Department of Labor notes that college students who participate in activities generally recognized as an extracurricular, they aren't considered to be employees within the meaning of the FLSA. So the courts so far have really held on to this principle. And although student athletes have tried to argue that their position at these schools is more akin to a work-study program, the court has generally rejected this argument and relied on this Department of Labor guidance in ruling in favor for the NCAA.
Right. So one of the most talked about aspects of this whole question and debate has been centered around the question of whether athletes should be able to form a union and collectively bargain their terms and conditions. Of course, just for background, that process is governed by the National Labor Relations Act, and it's administered, and that whole process of unionization and enforcement of it comes from the National Labor Relations Board. And under the NLRA, the act provides the right for employees to organize, collectively bargain their terms and conditions of employment. Now, the NLRA is sort of low-hanging fruit because the statute pretty much doesn't even take an attempt to define what an employee is. I know in the context of some other employment statutes, even the FLSA, it's somewhat vague or it's subject to a broad interpretation. It's just not really defined at all in the NLRA. And this has opened the door for groups that haven't traditionally been thought of as employees to seek benefits of the act, including student athletes. So this was the case back in 2015 in the very popular or public Northwestern University NLRB saga, so to speak. And in that matter, a union filed a representation petition seeking to represent about 85 scholarship football players at Northwestern. Northwestern in turn challenged the petition, arguing that the scholarship players were not employees within the meaning of the act, so they did not have the right to collectively bargain. So after an evidentiary hearing before the regional director of Region 13 here in Chicago, the director found the scholarship players to be employees under the act and actually ordered an election for the student athletes to vote whether they wanted to be represented by the union. And the gist of that decision was that scholarship players pretty much met the common law definition of an employee. In exchange for compensation, via their scholarships, they performed services that were a benefit to the employer, and they were also subject to the control of the university. So, the university dictated their schedules, and they generally dedicated about 40 to 50 hours per week just to football activities. Well, after that decision, the university filed an appeal with the actual five-member board, the NLRB board that reviews decisions from the regional directors. And in 2015, the NLRB reversed the regional director's decision. But if I could use a lazy sports pun here, they truly punted on the central issue in that case. So the board just simply exercised its right to decline jurisdiction, but it didn't really decide that statutory question of whether those athletes are employees within the meaning of the act. So the board instead noted that, and I quote, the policies of the act would not be effectuated by assertion of jurisdiction. They went on to state that, it's just not practical. They said would not promote stability in labor relations. And they point to a couple of factors. One is just the high level of control that comes from the league, so the Big Ten in this case, over all of the individual teams. They also point to the fact that, the Big Ten conference is primarily comprised of public institutions, and those institutions would not be subject to the NLRA. So you would have this situation where you have one school that could be organized in a league where no one else could be, as opposed to in professional sports where jurisdiction can be asserted over each team. So, I mean, at the basis, the argument is that this is not practical, this wouldn't work, so we're not going to assert jurisdiction. But they definitely left the door open and mentioned that in a different context, they might find otherwise. And I believe in some subsequent memos from the NLRB General Counsel, they actually took the position that, this could be the case, that private institutions, scholarship football players could be employees within the meaning of the act. But that actually changed any of these prior decisions. Quickly, just another area. Of course, sports injuries are part of the game, is very common, but they can have devastating and long-term effects on students. So students have sought to seek worker compensation claims through their state commissions. And of course, this is a function of state law. And within those statutes, typically there is some type of definition of what an employee is. And most courts interpreting those state statutes for the same reasons we've seen in other employment statutes have generally found that student athletes are not employees. And I mean, this goes back all the way to roughly 1957, one of the earliest cases to address the issue in Colorado. It was a Fort Lewis A&M player who was killed after an injury during a football game. And the Colorado State Court found that there was no contractual obligation for the player to actually play football, which qualified him for a workers' comp claim.
Another concern that we've really heard raised about compensating student athletes is centered around Title IX and whether it applies to these various types of compensation schemes that are out there. So the most prominent concern is really that Title IX would be prohibitive to college athletic programs because the cost of paying those high revenue generating players, such as your men's basketball players or your football players, plus then the cost of paying female athletes similarly to comply with Title IX would essentially bankrupt programs, or at the very least be highly impractical. I think it's super important to begin by noting that currently Title IX and its implementing regulations do not directly discuss whether there's a requirement for equal financial terms for all students beyond those provisions that apply specifically to athletic scholarships. Courts have analyzed some payment issues under Title IX, though, that I think are going to be really instructive in helping us foresee how a court might analyze athlete payment issues raised under Title IX. So for example, one of the models that we'll be talking about, and we have been talking about, is revenue sharing. And the US Department of Education's Office of Civil Rights has expressed concern in the past that private funds under models like revenue sharing would likely be cause for concern under Title IX, specifically because Title IX was enacted to address historical patterns of inequity between men's and women's athletic teams, and specifically because men's sports generally occupy a favored position in society that really results in stronger public support. So the issue then with revenue sharing is that Title IX's equal treatment mandate could kind of be undermined by a school being able to channel additional support for their men's teams through private funding. I'll note that OCR did make clear that receipt of private funds to support athletic programs, for example, booster clubs, does not in itself violate Title IX. But there is a concern under Title IX if the school then accepts private funding, because the school then has an obligation under Title IX to provide equal treatment and disperse those funds equitably. And some case law out of the Eighth Circuit really confirms this interpretation for us. It was a case called Chellenor v. the University of North Dakota, and there the court really held that once a university accepts private funding received from, for example, individuals, corporations, associations, licensing revenue from sharing agreements and sponsorships, that those funds then become public money and are therefore subject to Title IX's obligations to equally disperse those funds between men's and women's athletic programs. There's also, so there are potential issues with revenue sharing models. What about if the NCAA deregulates financial endeavors? So we actually have some case law out of the Supreme Court, NCAA v. Smith, where the court held that the NCAA's receipt of dues payments from recipients of federal funding did not sufficiently subject the organization to Title IX's requirements. So it didn't subject the NCAA to the requirements of Title IX. And the Supreme Court really made clear that Title IX's definition of recipient for purposes of determining who is subject to Title IX made clear that Title IX's coverage is not triggered when an entity is merely benefiting from federal funding. So while the NCAA currently controls regulations of student athletes regarding compensation and benefits, if it were to allow compensation of student athletes beyond mere, dues payments, then any violations of Title IX are likely not going to fall on the NCAA. They're going to fall on individual colleges and universities. So then discrepancies in compensation between men's and women's teams that are justified by greater popularity or more public support then fall to the college or university. And there's really an argument that if a university is responsible for implementing, monitoring, or allowing inequitable compensation models like this, then they may be deemed to have acquiesced to the system and therefore are responsible for consequences of unequal funding under Title IX. While there are some of these genuine Title IX concerns with some of the payment schemes based on the case law we just discussed, we have case law out of the Ninth Circuit that kind of holds a completely opposite viewpoint, Stanley versus the University of Southern California, in which the court viewed pay issues under Title IX as coextensive with the Equal Pay Act and the Civil Rights Act. And in that case, the court really held that it was permissible to offer the men's basketball team coach a higher rate of pay because the men's basketball team generated far greater revenues than the women's program. So at least in terms of coaching, courts have upheld that greater pay for male coaches is acceptable where their work has been found to involve greater skill, effort, or responsibility. And ability to generate revenue was one factor in determining whether there was greater skill, effort, or responsibility at play. So there is the possibility that courts may analyze the issue of direct athlete compensation similarly and find that programs such as men's basketball and football may earn more than women's programs because they're typically higher revenue generating programs that require greater skill, effort, or responsibility. On the other hand, there's still those issues I talked about in terms of fund disbursement and the purpose of Title IX to provide equitable opportunities between men's and women's programs that are likely going to be in conflict with that interpretation as well. So all this being said, there's really no provision of Title IX that directly prohibits unequal compensation. And there's also no case law on point because courts haven't tackled this issue yet. So we're really likely going to have to wait and see how this ends up playing out once those challenges are brought. But I do expect them in the future. And then switching gears a little bit, so we've talked about the case law surrounding this issue. What about the current legislative landscape? So several states at this point, including California, Florida, Colorado, New Jersey, Michigan, and Nebraska, have passed legislation that allows student athletes to earn money from the use of their names, images, and likeness. And approximately 30 other states have also proposed similar legislation, so we're going to wait to see whether those get passed. But I'm going to use the California law, which is known as the Fair Pay to Play Act, as an example of this type of legislation because it was one of the first state laws that really permitted compensation to student athletes for the use of their name, image, and likeness. It also allows college athletes to take on youth coaching positions, but the law does prohibit schools from direct compensation to student athletes, which is really similar amongst the other past legislation and pending legislation. The California law was passed back in 2019, but it won't go into effect until 2023. Most of the similar legislation that's already been passed has a 2023 implementation date as well. But Florida's name, image, and likeness legislation is set to go into effect in July of this year. So we're going to be able to see how it plays out in Florida relatively soon and kind of what, if any, effects there are there. I will say that NCAA has pushed back a little bit on this type of legislation because they're really concerned about there being a patchwork of legislation in various states that are going to hamper the NCAA's ultimate, stated goal of providing a fair and level playing field for students across the country, particularly where students in some states are getting compensated and in others they're not. And as additional states move closer to joining these 6 states who have already enacted legislation granting name, image, and likeness rights to student athletes, the number of proposed federal bills continues to grow as well.
So as far as federal legislation, the 2 big players this year are going to be the first 2 listed on this slide, the College Athlete Economic Freedom Act and the Amateur Athletes Protection and Compensation Act, both of which were proposed earlier this year in 2021. So first looking at the College Athlete Economic Freedom Act, this is a Democratic bill. It goes beyond what what there is in existing legislation as far as like what's been passed in the states. And it actually proposes new NCAA rules giving athletes very broad rights, including virtually unrestricted access to earning income from their name, image, and likenesses through either individual or group agreements. It also explicitly gives athletes the right to organize through collective representation. Additionally, athletes would have an antitrust right to sue under the Act. And with this piece of legislation, we should mention that there is some concern that with the provisions of this Act, it could effectively transform student athletes into employees because of the fact that they'll be able to enter into employment contracts. So this could potentially fundamentally alter their status as a student athlete. Next, we have the Amateur Athletes Protection and Compensation Act of 2021. This is a Republican-backed bill, and it was proposed by U.S. Senator Jerry Moran. It has been referred to as kind of a middle-of-the-range approach when you look at the provisions of this legislation when compared to other proposals introduced in 2020. It provides that athletes should be paid for their name, image, and likeness, and it allows athletes to sign endorsement deals as long as those agreements wouldn't violate the school's code of conduct. Recruits also can sign the same deals as long as that wouldn't be considered a recruiting inducement. And this piece of proposed legislation is unique because it allows athletes to enter into a sports draft and retain their college eligibility as long as they do not receive compensation from a professional sports league, team, or agent. Other notable provisions, the Act provides a lifetime scholarship for former athletes and grants them the ability to transfer at least once without penalty. The bill clearly states that college athletes will not be considered employees, and it protects the NCAA from liability to former athletes retroactively seeking compensation. As far as benefits, this bill states that schools must cover athletes' post-participation medical expenses for at least 2 years if the school gets revenue exceeding 20 million, and 4 years if the school's revenue exceeds 50 million. So in sum, this creates a national standard and provides some benefits and allows student athlete compensation while explicitly stating that student athletes will not be considered employees. So the other bills listed on this slide are from 2020. And they do have some notable provisions which kind of provide insight into what's being considered. If we can move on to the next slide. So all of the federal proposals we listed provide for compensation based on name, image, and likeness. However, there are variations throughout the bill that target various equity issues. And we've kind of parsed them out on this slide. So you can see some of the provisions that are being considered depending on which legislation you're looking at.
Yeah, and Carolyn, one thing to mention, we will be distributing along with the PowerPoint presentation a summary of all the various state laws that have been passed and proposed along with the pending federal legislation. So everybody on the panel will look at those provisions in more detail.
Yes.
Thanks, Mike and Caroline. So, we've seen a lot of proposed legislation both at the state and the federal level, and I think the NCAA was also watching these developments, and in response to the proposed legislation, the NCAA issued a report stating that they were open to adopting a rule that would allow athletes to profit from the use of their name, images, and likeness. And so then NCAA began working on some proposed rules. And under those rules, it would have allowed student athletes to receive compensation for third-party endorsement related to athletics and the student name, image, and likeness, subject to some restriction. And the NCAA really emphasized that any compensation that student athletes would receive, it could not come from or even involve the institution at all. Again, you can see it through all of these proposed acts or rules that there's a concern not to trigger that employment relationship. Now, simultaneously, while these rules were being worked on, the NCAA also was very vocal about their support for federal legislation as opposed to state individual state regulation on the matter. And then Emily kind of got into that reason why, the whole patchwork. You want a sort of blanket policy. And they also made a recommendation to Congress to include in any federal legislation a sort of safe harbor provision that would grant them immunity from antitrust suits. So while that was out there, these rules were set for a vote. Just January of this year, the U.S. Department of Justice Antitrust Division wrote a letter expressing concern that these proposed rules could actually violate antitrust law. And also they were very vocal in this letter about their concern about the NCAA seeking or encouraging legislation that would grant them immunity from antitrust laws. So in response, the NCAA announced that they will postpone their deadline to actually vote on the rules. And I mean, I think the speculation is that they just want to wait at this point to see if and will Congress will act on that issue. So, we're kind of just waiting to see what's going to happen at this point with some of this proposed legislation.
Okay, so now that we've gotten through all of this background, keeping all of this information in mind, I want to get into what we think is going to happen next. And again, if anyone listening has any opinions or thoughts on these topics, we certainly don't have all the answers at this point. So please feel free to include your thoughts in the chat or ask questions in the Q&A function. We would love to hear from you and what you think is going to happen next too. So let's start out with Mike. Do you think the NCAA is going to act on its own?
If history is any guide, it's unlikely. This has been a chronic issue that people have been debating as long as I've been following college sports. And everybody recognizes there's an issue, but I think the incentives are such that the NCAA itself, absent being forced to do so either by Congress, state legislators, or the courts, is not inclined and probably not able to, due to various reasons, to revive the current system on its own. It's just too entrenched, and there are too many complicating factors.
Caroline, what do you think? Is the NCAA going to act? I know Mike says no. What do you think?
I think it's certainly possible that they may do something, given all of the states kind of taking their own initiative to try and figure out this issue, as well as the federal legislation that's currently pending. I think it's really going to depend on how things move forward, what seems to be included in this legislation. So I think they might try to get ahead of it and kind of restructure themselves in a way that still preserves their principle of amateurism. I don't know if this would really be considered them acting on their own or kind of being pushed into a corner. So I think this year is going to be important in seeing what gets done.
That's a great point. Let's say if we take Caroline's position and the NCAA does end up acting, Jason, do you think that their proposals are really going to be sufficient to alleviate some of this public and political concern, surrounding these rules?
Allow me to channel my inner Stephen A. Smith. Absolutely not. The central issue, and at least in the public discourse, is the fact that the students are not receiving any type of direct payment for their performance. That's what brings in the revenue. So at least from a public standpoint, the NCAA proposals are more focused on improving profiting from your name, image, and likeness, but it doesn't hit on that kind of that pressure point issue for most people in the public, is that that compensation portion of it, the organization rights, things like that. So and I'm in no way advocating one way or the other right now, but I don't think that what has been proposed in the public court of opinion is gonna fly.
Yeah, I think I tend to agree with you that really the short answer here is probably no. A lot of the issues we raised today are still going to be at play there, right? We still have these equity and fairness issues of whether athletes are being fairly compensated for the work that they're doing, and whether that compensation is fair in terms of what coaches and universities are also earning based on, their efforts. So I do still think that, there's also going to be some of those Title IX issues that we talked about that are going to be raised, that are still going to be in play regardless of whether the NCAA passes these rules or not. So if we don't think the NCAA is going to pass rules, or even if they do, how likely is federal legislation? Caroline, you want to take a stab at it?
Sure, I'll at least get us started. I do think that there is room for some federal legislation here. If you look at all of the proposals that have been put forth so far, there are definitely some common themes. I think people on kind of both sides of the table are willing to provide compensation for the use of the names, images, and likenesses of these athletes. But I think the question really is, how far are we going to go beyond that? So what will Congress do for the student athletes? Will they legislatively say that they're employees or that they're not employees? Will they provide them the ability to bargain? What does their healthcare kind of look like? So I really think it's a question of how far Congress is willing to go, and how, and consider the states as well, and how far they've already gone.
Jason, what do you think?
I agree with Caroline, and I think, is it likely is the easy question, yes. And as Caroline brought up, how far would they go? Personally, I think people much older or wiser than me have a saying that pressure bursts pipes or creates diamonds. So I kind of feel like how far this legislation is going to go is going to be tied to just how much pressure is continually placed on the officials who are drafting these laws. I think that's what it comes down to. We're going to have some guidance from the court, but I really think that pressure that Congress receives is going to be what defines how far we'll go. I think at a minimum we'll see the continuation of athletes being able to benefit from their name, likeness, which was not the case prior to this. But will they begin to be compensated? Will they have some form of organization rights? I just think it's tied to the amount of pressure that Congress gets.
How about you, Mike? Any thoughts?
So to Jason's point, I do see a lot of pressure building up, but I think you can be, it's a fool to bet on federal legislation actually going through, given the polarized nature of politics these days. For all the reasons we've pointed out, I think there is a lot of common ground and a need for some uniformity and consistency. So I would hope that the powers that be, including Congress, including the NCAA, can come up with something that salvages both what's great about college sports while making the necessary reforms. I do think that the state legislative action may cause the tipping point, because I do think from a standpoint of, what is important, and that's maintaining the, competitive balance and the money-making machine of college sports. To a lot of people, having 50 states regulate these issues, is not a viable option from a pure business perspective. Setting a, before you get into the real significant educational, legal, and equity issues we've talked about. And I hate to be cynical, but unfortunately, the business pressures are ultimately what may tip the balance in this. It's unfortunate that's the way it is, but that's tends to be how things happen.
So kind of, we were putting this all together. One of my thoughts was, what happens if the NCAA, or Congress don't act at all? And I think one of my thoughts is that we're really going to see, like we talked about, this piecemeal approach where different states are enacting their own legislation to react to public pressure. But my concern would be that this patchy approach then ends up really exacerbating some of the inequity that we're already seeing, by adding in this additional factor that athletes in some states or at some schools are now going to be compensated for their name, image, or likeness or otherwise. And in other states or at other schools, they're not able to do that. Does anybody else have thoughts? Mike, you want to take a shot at this?
Absent legislation, I do think there's going to be continued litigation. I do, from a lawyer who represents employers and colleges and universities, I am worried about for our clients what's going to happen, because I do think, given all the pressure that Jason pointed out, and also given the NLRB could revisit its position. The Department of Labor could be much more receptive to the sort of arguments that Carolyn identified, as far as players being actual employees. The reality is Division I athletes are a hybrid. There's no doubt about it. They are there to play sports, and that takes a substantial amount of their time, and makes them different from students. But also, it's hard to envision them being paid purely and treated purely as employees. And what often happens is, absent coherent law or legislation, people look to courts and agencies to fill in the gaps. And I think that is, if that happens, that's going to just compound the situation and make it not be good for our clients, and frankly won't be good for college athletics.
So we've got 1 minute left. I'm going to ask us to do a lightning round. Give me your 1 to 2 sentences. What do you think is the most likely outcome here? Jason, I'll start with you.
All right. Never ask a lawyer for 1 sentence, but first, I think our higher ed clients here are, if you're on this call, this is the right thing to do right now, to stay up to date on what's going. There's not much policy internally to be changed right now, but you're doing the right thing by continually to monitor this, and we're going to continue to do that. As far as what I think is going to happen, I think we're still a fair amount of years away from this kind of landing, but I think if it lands anywhere, it will be somewhere in the middle. I think that's just how things tend to end up. I don't know if it's going to go all the way to employees just receiving checks after every game. I doubt that would be the case, but I do see more being given to student athletes.
Caroline, how about you?
So in 1 sentence, I think if whatever legislation is passed doesn't include some type of language or provision saying that student athletes are not employees, we're going to see this issue keep getting filtered in, and they're going to keep litigating it. So.
All right, Mike, bring us home.
So, given that my my beloved Blue Devils are not in the tournament for the first time in forever, I'm going with the Illini. Not to be too much of a hometowner, but I predict the Illini are going to go all the way, going to upset Gonzaga, so that's my prediction. But seriously, I do think we are getting to the point, and I think the pandemic and the horrendous financial burden that's placed on colleges and universities and challenges may create the tipping point needed to really to have people look at this. And I do think some form of federal legislation is likely.
I do see in the chat we have some Duke fans, so you're not alone, Mike.
I'm a proud Illini fan. I should have worked that in earlier, but Mike is spot on.
I see I can't forget Loyola and Sister Jean. I do see a comment about that. So
we so appreciate everyone sticking with us today. This panel is full of college athletes and clearly sports enthusiasts. So we had fun kind of tackling some of these issues, and we're going to be following up with updates and keeping track of this just as much as you guys are. So if any questions arise on any of this, please feel free to reach out to any one of us or anybody at the firm that you know of or don't know of and might want to start talking to. So thank you so much, and hope you guys have a great rest of your day.
Thanks, everybody.
Thank you, everyone.